Welcome to Tech Talks with Kinsoft.
Glad to be here for this one.
Yeah, so usually when an organization builds a system to protect something incredibly valuable, the instinct is just to obsess over the physical boundaries.
Right. The geography of it all.
Exactly. The boardroom questions are always, where are our servers located? Which data center is this in? Do we have a primary and secondary site within our own borders?
It makes sense, right? I mean, humans are wired to understand physical geography. A data center in Sydney, it feels tangible. It feels safe.
Yeah, you can point to it.
Right? You can point to it. And the assumption is that if the data is physically sitting within the walls of our country, well, it's inherently protected by our legal frameworks.
But the danger there, of course, is that a fortified physical location means absolutely nothing if you casually hand out a master key to an unvetted third party.
Oh, absolutely. Especially one operating in a totally different jurisdiction.
Right. And that is exactly what we are getting into today. In this exploration, we are taking a massive stack of sources reports, investigative articles, corporate statements, and extracting the absolute most crucial insights.
You don't have to sift through all that raw reporting yourself.
Exactly. Our mission today is analyzing a massive real-world failure in data sovereignty, security governance, and third-party contracting. Now, if you are listening to this analysis, you're likely already managing these complex risks in your own environment.
Which is why this is so relevant.
Right. But I do want to set a firm ground rule for you right at the top. We are keeping this strictly professional.
No sensationalism.
None. We are not here to dramatize the situation. We're not speculating about individual court cases or the people involved. We are simply looking at the architectural IT and the security failures.
Because the core tension we're unpacking here, it represents a really fundamental misunderstanding in modern enterprise IT.
It's the classic trap.
Yeah, the trap of confusing where data is stored with who actually has access to it.
So let's start with the mechanics of the incident to understand how the breach actually occurred. This helps map out the attack surface before we dissect why the governance failed.
Good place to start.
So in February 2026, this was actually broken by ABC News on February 16th, and then we saw a company statement follow up on February 2024. It emerged that a Canadian transcription provider, VIQ Solutions, had breached its Commonwealth contracts.
Right.
They were contracted to do Australian court transcriptions, but they subcontracted that Australian work to E24 Technologies, which is a firm based out in India.
And that is the crux of it, because this resulted in highly sensitive federal court, federal circuit, and family court files being actively accessed offshore.
I try to think about it like this. It's like renting a highly secure bank vault in Sydney, right? But then leaving a live webcam feed of the open vault just completely accessible to someone in another country. If they can see the feed, does it really matter that the physical paper is technically in Australia?
It doesn't matter at all. That analogy is spot on. And this brings us to the difference between data residency and data sovereignty.
Which people mix up all the time.
Constantly. So notice the defense from VIQ's CEO, Larry Taylor. He stated, and I quote, "All customer data is stored in Australia in accordance with the Privacy Act 1988.
Right. Stored.
Exactly. Stored. That defense misses the point entirely. Data residency is just where the data sits. It's the geographic location of the hard drive.
But sovereignty is the access part.
Right. Sovereignty is about who is legally and operationally able to view and process that data. So Larry Taylor saying the data is stored in Australia, well, that's practically useless if offshore staff with Indian IP addresses are actively accessing those files.
Right. If you have remote read and write privileges, the physical location of the server rack is totally relevant.
Exactly. The physical layer was secure, sure,
Yeah.
but the application layer was completely porous.
Okay, so the technical mechanism makes sense. Storage versus access. But this brings us to the human element, which is honestly wild to me.
The internal governance failures.
Yeah. Why didn't internal governance catch this or stop it? Because you don't just set up an offshore pipeline without some alarms going off.
And the alarms did go off. Loudly.
Right. The reporting shows that internal staff actually raised alarms about this unvetted offshore access as early as August 2025.
Months before it broke the news.
Months before. And management's response was basically to dismiss them. They told staff the concerns were, quote, not relevant, and told them to stop spreading rumors.
Which is just a textbook failure of security culture.
Oh, it gets worse. Management even issued an internal memo falsely claiming the E24 resources were based in Sydney.
Wow.
Yeah.
Okay.
And meanwhile, there's this massive turnover happening. Since July 2025, at least 12 senior staff either quit or were made redundant. And then the absolute kicker, they fired the entire quality assurance team.
That is the part that just screams structural collapse.
Right. So the remaining contractors were suddenly forced to do unpaid quality control on these E24 transcripts. And these transcripts are coming back at impossible human speeds and were full of major errors.
Which heavily implies unvetted automated AI being used in the background.
Exactly. But wait, so the automated transcripts are coming back full of errors, and their response is to fire the quality assurance team. Isn't that like cutting your parachute strings while you're already in free fall?
That is exactly what it is. I mean, from a security governance perspective, this is a total collapse. What you're seeing is a culture of silence.
Right.
When you dismantle internal auditing, like firing the QA team, you are removing the necessary friction that keeps an organization secure.
Friction is a good word for it.
Yeah. In security, friction is a feature, not a bug.
Yeah.
QA teams, compliance officers, they purposefully slow things down to ensure safety. But here, they prioritize speed and cost-cutting over rigorous internal compliance.
They didn't want the friction.
Right. And when you remove the people asking the hard questions, you basically unplug your own anomaly detection.
Which leads us directly to the national security ripple effect, because we need to look at exactly why where your data is processed matters on a macro scale.
The payload itself.
The payload. This wasn't just mundane administrative stuff. The compromised files contained incredibly sensitive data. We are talking about evidence from ACSC and the Australian Federal Police.
That is about as sensitive as it gets.
Right. The reporting notes this potentially exposed covert operatives, protected witnesses, and international criminal links.
And the technical proof was sitting right there in the logs.
Access logs showing offshore staff viewing files outside of Australian business hours.
Which is a massive red flag.
Huge. And ultimately, the matter had to be referred to the Australian Cybersecurity Centre. Now, the sources also discussed the political reactions, specifically from Green Senator David Shoebridge.
Right, he was very vocal about this.
He was! He called this a national security risk. He urged the termination of the contract, and he labeled the situation a failed privatization. Now, I want to be very clear for you listening right now.
Yes, an important note here.
Yeah, we are neutrally reporting the contents of the sources. We are not endorsing Senator Shoebridge's political viewpoints or taking a side on privatization. We are simply conveying the perspectives that are present in the material.
Our focus is on the architecture.
Exactly. But looking at the architecture, the senator did make a point about set and forget contracts. And I have to ask you, how do standard vendor risk assessments completely miss the true sensitivity of a payload like this?
Well, that phrase, set and forget, really hits the nail on the head. Standard vendor risk assessments, or VRAs, they usually happen at the very beginning of a contract.
Right, during procurement.
Yeah, you check their ISO certifications, you look at their data policies, and you approve them. But initial due diligence is completely useless without ongoing, continuous auditing.
Because environments change.
Exactly. Vendors change their software stacks, they change their personnel, or like here, they quietly subcontract the work. If you treat a VRA as a one-time checklist, you are blind to those changes.
And the automated systems, why didn't they catch this?
Well, they should have. Offshore access outside of local business hours is a glaring anomaly. If you have a properly configured zero-trust environment, an automated monitoring system should instantly isolate that session and lock it down.
Right, it shouldn't just be a line of text in a log file that someone finds months later.
No, it should be an active automated trigger. But if you are in a set-and-forget mindset, nobody's looking at the logs, and the automated triggers aren't configured to stop the bleeding.
Which brings us to the actual contractual agreements. We really need to bring this down to the listener's own environment.
The subcontractor blind spot.
Yes, how contractual controls basically fail in the real world. So according to the sources, the VIQ staff in Australia, they had to undergo national security checks.
Makes sense.
And they had to sign a Commonwealth court's deed of confidentiality.
Yeah.
Very strict stuff. But it was completely unclear if the E24 staff in India underwent any of the same vetting.
Right, a massive discrepancy.
Yet, the VIQ CEO stated publicly that contractors like E24 are, quote, required to adhere to the same strict privacy guidelines, service delivery standards, and confidentiality as all employees.
Which is a bold claim to make.
Right. It's like hiring a highly vetted security guard for your office building, but then that guard secretly outsources their night shift to a random stranger on the internet.
Yeah, just completely undermining the whole system.
So how does a company actually enforce contractual controls down the supply chain? Does a contract even do anything?
Well, what you're describing is what we call the illusion of inherited compliance.
The illusion.
Yeah. It is this false belief that just because you wrote a strict standard into a legal contract, that it magically translates into technical security.
But it's just paper.
Exactly. A legal contract is a remedy for after a breach happens. It does not stop a breach from happening. Saying a subcontractor must adhere to guidelines means absolutely nothing without technical controls to physically enforce it.
So what do those technical controls actually look like?
Well, it requires strict access management. It requires geofencing.
Meaning literally blocking IP addresses outside of Australia.
Exactly. The API gateway should just drop any query from an unapproved region. But it also means you have to control the endpoint. If a remote worker needs to transcribe a file, can they download it to their local hard drive?
Right. Or can they just copy and paste the text into an email?
If the answer is yes, then your contract is useless. To enforce it technologically, you need things like virtual desktop infrastructure, or VDI.
Where the data never actually leaves the server.
Right. The remote worker just sees a secure pixel stream of the application. You disable their local clipboard, you block print screen, you lock it down completely.
But companies don't like doing that because it adds that friction we talked about.
Exactly. It slows things down, it costs money, vendors complain. So companies cave. They accept the operational risk and just hope the legal contract will protect them.
And as we've seen today, a contract cannot secure a digital perimeter.
It absolutely cannot.
So we've covered a lot of ground today. The storage versus access trap, ignoring the internal alarms, the national security implications, and the danger of inherited compliance.
A lot of hard lessons here.
Very hard lessons. And we want to leave you with a lingering question to think about in your own architecture.
Something that builds on all of this.
Exactly. If a supposedly mundane administrative task like transcribing court audio can accidentally expose covert operatives and national security secrets,
Right.
what harmless outsourced services in your own organization secretly hold the keys to your most sensitive data?
Is it your marketing analytics vendor?
Is it the AI chatbot widget on your website? Your payroll processor?
It's a terrifying thought, but you have to look at the basement doors, not just the front gate.
You really do. You have to evaluate your third-party risks constantly. So, before you sign off on your next vendor agreement, we want you to take action. You need the right experts to help you build those technical fences.
Don't rely on the paper contracts.
Right. So please visit www.kinsoft.com.au to discuss your security and IT needs with the team.
Get those technical controls in place.
Thank you so much for joining us on this exploration today. Protect your boundaries, and we'll see you next time.